very good morning to everyone. I, Anushmi Jain, Faculty of Law, on behalf of the ICFAI University Dehradun, ICFAI Law School, would like to welcome you all on the second day of 4 days National Virtual Workshop on Intellectual Property Rights. On the first day, we had Advocate Mrs. Snigdha Sharma, founder Meglex Private Services Limited, Bangalore, who dealt with the topic of copyright, and today she'll be dealing with the topic of trademark. It is requested to all the participants to fill the feedback form which shall be circulated both on the Zoom chat box as well as YouTube comment section only during the session in order to mark your presence. Now, I would like to call upon Professor Dr. Yugal Kishore, Dean, ICFAI Law School, to give welcome address. Sir.
Okay. Thank you. Thank you very much, Madam Anushmi Jain ji. But anyway, so my learned speaker and the distinguished academician from different universities, pan-India, professionals in the subject of IPR, as well as the student friends. We have started 4 days national workshop on intellectual property right yesterday. Many of you were here yesterday, and you have discussed and on copyright issues. Today, Madam will be here. Madam will be discussing about the issue of trademark. The yesterday's the deliberations were very lucid, informative, and to the point. Today again, I'm very sure that whatever Madam will be discussing with you will be very much beneficial to you in your learning process as well as in your practice procedure. In simple way, I can say that trademarks are brand name or logos which we find on the product or the services. And here, many times the identity of the particular trademark or symbol, whatever it is very similar with the other, and creates a lot of problem. So many legal issues come in. Of course, I'll not go in detail. Our madam is there. She will be elaborating upon all these things. And nowadays, along with the trademark, trade secret has also come in. So there are various issues which will be discussed in all these 4 days. And with this, I welcome all of you again to this 4 days virtual national workshop on intellectual property right. And thank you for being with us. And yesterday, we were very fortunate that the number has exceeded more than 500 as far as the Zoom network is concerned, which is having capacity of 500. And apart from that, a large number of participants were there on YouTube also. So we are grateful to you that all of you have come and you want to learn something from here. So with that, now I request Madam Monica Kharola to please speak some few words on something and some issue.
Thank you, sir. Basically, I was, to introduce Ms. Snigdha Sharma to the participants, whose introduction was done yesterday also. But for the benefit of those who joined today, we would like to, give a brief of a recap of her introduction. Ms. Snigdha Sharma is the founder and director of Meglex and specializes in corporate and intellectual property law. She also serves as a director on the board of several companies. Ms. Snigdha did her graduation and post-graduation from Bharati Vidya Peeth New Law College. Ms. Snigdha is proficient in reviewing and drafting contracts across multiple domains. She has core expertise in matters related to intellectual property law, company law, and insolvency code. Her practice primarily revolves around analysis, strategy, and effective execution in finding solutions to legal problems. Key verticals she has personally handled include business development and relationship management with clients across domains. With this introduction of the speaker for the day, I would like to hand over the mic to Ms. Snigdha. Thank you.
Thank you, sir and ma'am, for such kind words of introduction. Uh, now that I'm very grateful to all of you to give me this opportunity to come here and speak to all of you. It was yesterday's session was very nice. I really enjoyed it, and hopefully you understood a little bit about what I tried to explain. And today also I'll try my best. To begin with, shall I start my session?
Sure.
Yes, ma'am.
Yeah. To begin with, today's topic is Trademark Act. I'll start with the introduction of intellectual property law. Yesterday also I had given this session, but for the people who didn't attend yesterday, so I'm stating the same today also. So what is an intellectual property law? How the concept of intellectual property law came into the picture? Post that only we can go to trademark and various other acts. Intellectual property means it is also a type of property. Property is a wealth for everybody. It's a creation of wealth. So by an individual, we can use and enjoy to the exclusion of it. This is the basic concept of intellectual property law. Now, when a human person comes up with certain intellect of theirs and comes up with something new, that has to be also protected, just like our general property. That was the concept on which intellectual property was coined. There are various definitions of intellectual property you will find. I am following the one given under WIPO Act by Stockholm. Intellectual property includes the literary, artistic, and scientific works, performances of performing artists, phonographs and broadcast, intentions in all fields of human endeavor, inventions, industrial designs, trademarks, service marks, and commercial names and designations. The whole thing is done for what? For protection against unfair competition and all other rights resulting from intellectual activity in the industrial, scientific, literary, and artistic work. What are the types of intellectual property? There are various types of intellectual property. Trademark is one of the types which we are dealing with in detail today. Other than trademark are copyright, which I have explained yesterday. Basically, nothing but copyright protects all artistic, literary, performing rights. For example, any movie, any book, all of them are a part of Copyright Act. Patent needs an invention. To protect the patent, it has to have a functional value. Novelty should be there, usefulness should be there. When we prove these two things, we can say that we can apply for patent protection. Example, Maruti engine. Trade secret has come up very new, and it's a very old concept. From the time of Coca-Cola, we have already knew about trade secret, how the method of Coca-Cola was saved. That is a trade secret. Geographical indication. Every part of the country has certain specialty of this. For example, Punjab is famous for the basmati rice, Assam for the silk, then Goa for the fenny. Like that, various states have their various categories. So to protect that, it comes under geographical indication. Design, but this is also a type of patent for the descriptive features. For example, the design of a car, the design of a plate, all these things comes under Design Protection Act. Now, design is again subdivided into the layout design of semiconductor chips. That is, the mobile, we have certain chips for which we use. Every small chips which is there, that is a microchip that can be protected under the layout design. A new act had come up in the picture in 2001 to protect the farmers and their plant varieties that they come up. That is called Protection of Plant Varieties and Farmers Right 2000. What do they protect? They protect the new growing, new types of fruits we grow, new types of plants we grow. So the person who is growing has to get certain protection. They cannot stop going to the market to sell that. So they are given right under this IP protection. And example of that is like a type of kidney bean or jute. All these things comes under plant varieties and farmers' right. Now let me discuss with the concept of trademark, for which today we are dealing with. Trademark. What is a trademark? First, let's go to the definition. Trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others, and may include shape of goods, their packaging, combination of colors and covers both goods and services. This is what trademark had been defined. Basically, when I say a brand, trademark is nothing but a brand. A person starts their business. A person starts its own product. He has to protect it. Everybody has to know it. They cannot know it by the individual's name. They has to know it to a certain category. That becomes a brand. Example, Reliance is a big brand. Everybody knows. Reliance means whenever we say Reliance, it is associated with Mukesh Ambani or Anil Ambani. So this is how Reliance had come into the picture. Reliance is a trademark. Now, here, if we concentrate on the definition, the word represented graphically is taken in very serious note. That means anything which we can see visually, that has been protected. But now certain changes are happening on that. Other parts of the world are already working on that. For example, holograms, mail marks have already come into picture. In that, it's still slow. It's not yet in the progress. They are progressing on it, but not yet. We cannot say it has come into that effect all today. Example of what I can say is trademark we can include into various categories. First one, I can say service mark, product mark, collective mark, certification trademark. If you check Trademark Act, you will find various categories. This is how I have categorized trademark. It is not necessarily this is the only way of categorizing it. There are various ways of categorizing it. Trademark has various classes. That is, when we file a trademark application, there are 45 classes to protect with. Now, when I say there are 45 classes, 34 classes talks about product, goods, and the rest talks about the service mark. So any application which is made up from the application class 35 to 45, it can also be defined as service mark. That is service-oriented business. For example, education is a service. It's a professional service. It is not goods. So if I go for ICFA University also, it will be under a service category. That will be a service mark. Product mark is a goods. Any sort of goods you want to protect it comes under the product category, which is within class 1 to class 34. And example, Amul. Everybody will know that. Certification of mark. Now, certification is a broad category where a board comes into the picture and certifies that this product is of this type of quality. It's basically a quality, a type of quality. For example, Coffee Board has done a certification of mark of various coffees, types of coffees. When I buy the coffee, I'll get to know that this coffee is of this quality. So this is Mysore Nuggets is also a category. Collective mark. When I say collective mark, it is also a broad category with various people coming together as a institute. For example, chartered accountants, entire institute of chartered accountant, once they pass out, they're given the certification of CA. That is called collective mark. I can say CA. Again, I've further divided trademark with the application that we can make. These are all the things which is applicable in India. Shape of mark. Coca-Cola bottle that has a shape registration. The shape is protected. Color mark. The Cadbury packet that has a color visualization. People know it by the color. That the purple color chocolate box is called a Cadbury. It's a part of Cadbury category. So that is the color protection we do. When we file a trademark application, we can definitely, in the application form, we have to make sure what type of protection we want, we write it. Sound mark. Now, this is very new that has come up. It is not very common. It has started from USA, but in India also we have started getting protection. Example is ICICI Bank corporate jingle that we have done. Word mark. Any name application that we go for is a word mark application. Where we do not use any fonts, where we do not use any design, that comes into the word category of trademark. Example again, Coca-Cola. Logo mark is the symbol, is the design that we protect. Nike symbol. Symbol mark. Again, that is also a logo, a type of logo. And the symbol is, for example, McDonald's M is very famous. Slogan mark. Slogan is the tagline that we use for any company. So, example, again, I'm using the McDonald's example. I am loving it. As but in the Trademark Act, there are various important definitions that we'll figure out. It is not possible to complete an entire discussion in one class. However, few categories I have figured out. This is very important to understand the basic concept. Whenever there is any objection of a trademark, when we do a filing of an objection, when we file an opposition of a trademark, we have to revert back to the reply. Most of them come up with the statement that our mark is a well-known mark. So what is a well-known mark? A well-known mark is a mark that has gained sufficient recognition among the consumer due to the usage and popularity of the mark. That is, people, when I just think of it, when somebody says Google, I will know about the Google. When somebody says Whirlpool, I don't have to figure out what is Whirlpool. I will know that it is talking about the fridge or washing machine Whirlpool. These are very well known. People know it all over the world. This becomes a well-known trademark. It is not necessary that well-known mark has to be only in India. It can be all over India. A well-known mark have its goodwill and reputation protected across the nation and across categories of goods and services. What happens when we file a trademark? We protect the particular mark in a particular class. The class is considered, that is the 45 classes I'm talking about. Those are the categories. So whether it is a category of soap or whether it's a category of education or a marketing business, anything, various categories have various classes. So each application that we file is for that particular class only. However, when we talk about a well-known mark, it doesn't belong to only particular class. It belongs to the entire donor. It is a well-known mark. The goodwill is associated with all donors. No one can file Google, since Google is a software thing, it is under class 35 and 45. So I cannot file a word Google for maybe a cattle feed. Just giving you an example, I cannot file that. Because Google has its own brand associated with it. Who stops getting the registration? The trademark registry itself stops it from allowing to register the mark. They cannot register any mark which is deceptively similar to a well-known trademark. What was the object of Trademark Act when it came into the picture? The object is every mark, every brand of the business identifies the product and the origin of the mark. For example, hammam soap. identifies the soap is originating from the Unilever business. We can talk about the manufacturer of it when I talk about hammam. It doesn't mean hammam, we never say that hammam is a Tata manufacturing company. However, we know that hammam identifies the brand of Unilever. How it happens? Because of the brand consciousness. It protects the product and its origin. Now, when I talk about hammam again, I understand hammam will be of a particular quality. That quality is also specified along with the trademark. If Lux will be a different quality, Dove will be a different quality, hammam is a different quality. When I think of buying a soap, I have to think which quality I needed. And every brand has associated itself with the quality. That is the power of a trademark. It advertises the product. When I say hammam, I will know that it is talking about soap. It is not talking about certain electronic goods. When I talk about Sony, it talks about electronic goods. It is not talking about any other item. So the brand itself is identifying with its product. It has an advertisement by itself. The marketing is already done with the brand registration. When I talk about all these products, it had the images in my mind about that particular product. When I talk about hammam, I think about the green color soap. When I talk about McDonald's, I talk about M. When I talk about Google, I talk about the Google ad that we always see. So every brand has its own image, which everybody as an individual, as a layman who is not knowing, who does not know anything about trademark or brand, but it is associated with our mind. That is the power of trademark. When I talk about Trademark Act, again, I just mentioned about the object and what does a trademark do. What is the reward of a trademark? The reward of a trademark is that the brand is associated to me. I get a goodwill about it. The reputation is with me. Everybody knows if I have to value my company, the valuation of the company will be based on the goodwill that I have created. However, what happens if somebody is trying to infringe that? What is an infringement? What is that if I'm trying to use the same brand in a different business and I am not, without my permission, I am the owner of a particular brand. Neglex is my brand. Now, if somebody comes up with another law firm and using Neglex, it is an infringement. So, what exactly is infringement? Infringement means using a mark falsely. That is someone else is trying to sell his goods or symbol, which is quite popular, using that particular symbol. Almost similar or quite similar or exact similar. There are cases which have been exact similar also. The term infringement can be used only for a registered trademark. If I have to give you an example of an infringement, Reliance is such a big industry. Everybody knows about a Reliance. If somebody comes with a product called Reliance, I will think it is associated with Mukesh Ambani's business. So at that point, if it is not with Mukesh Ambani and some third party is just coming to sell his goods, thinking that I can use that thing, that is infringement. Passing off. Just like similar to infringement, passing off also is using the mark falsely. But what is the difference between infringement and passing off? Infringement is a remedy or is available only for the registered trademark. However, trademark is not a compulsory registration. If I want to create a brand, it doesn't mean that I need to go under the Trademark Act and protect it and file it. I can do it even without filing it. So if I don't file it and if somebody is copying it, that is called passing off. Passing off is a common law tort which is commonly used to protect goodwill that is attached to the unregistered trademark. Passing off is basically when one person is passing off his goods, that is trying to sell his goods or services as that of another person. An action of passing off is available to both registered and unregistered trademark. Here I've given a differentiation between infringement and passing off. Let's talk about it one by one. As I already mentioned, available for registered mark only. Infringement suit, if I have to file, it is only for a registered trademark. Passing off can be filed for both registered and unregistered mark. To file a suit of passing off, we have to show the constant use of the mark. If I have a trademark and I registration, but I want to file a passing of suit, I have to show that the mark is being used. It's not that I want to use in future. Trade infringement is a statutory remedy, whereas a passing off is a common law remedy. Infringement protects the exclusive right of the registered trademark owner, and passing off protects the limited right of the unregistered owner. As a trademark owner, when I file a trademark, and I get the exclusive right on the intellectual property. Just like I mentioned in the beginning of the class, what is a property and what is the importance of property. So to protect that, I get the entire right. Whereas if I do not file it under the Trademark Act, my right is limited. Example of our infringement is McDonald's this, and this is someone trying to copy that called McDonald's. The remedies available for a registered trademark holder. Number one, to file an injunction suit. That is, if I find out anybody is trying to copy my trademark, I go to the court telling them to stop that business, to stop that immediately. That is an injunction suit. Search and seizure order, that is, if already they are using lots of pamphlets or advertising brochures, I have to stop them from going to the market. So immediately I go to the court asking them to stop advertising and collect all the pamphlets, advertisement copies they have. Criminal case can be filed for any infringement matter. The trademark registered has the power to to take action against any sort of infringement. For example, withdrawal of the trademark or do any such necessary action, the register can take immediate course of action. As I told you, the registered trademark is also an exclusive property. I own that property. What happens with my own property, my house? I can sell it to somebody, I can give it to somebody, I can do anything with that. Similarly, trademark is my property. If I own it, so I can do anything with that property. I can give it to somebody as a gift. I can give it to somebody as a royalty. I can do anything I want. Now, assignment is a type of act which we do when we want to give our trademark rights to somebody else. For example, I own a trademark and I want to give it to ABC to use the trademark and to use it as its own. I do not want to have any further right on that trademark. I can take money for that. I can give it as a big gift. So that comes under assignment. When I file an assignment application in Trademark Act, I have my entire rights on the trademark will go to the new applicant. Transmission under Trademark Act, when a person, I am the owner of the trademark, I die, then my legal heir will go to itself. That is the operation of law, devolution, anything, it goes by in that mode. License. Trademark license, the license in Trademark Act is not defined as such, but people practice it through the license agreement. That is, a part of that trademark can be used for a particular exclusive purpose. I own the trademark, I give it to ABC to use the said brand, but he cannot do anything with that. He can just use the said brand, stating that he has the power on that brand. That is the max he can use it. Rest of the rights remain it with me. If he has to further give it to somebody, he has to take the permission from me. So license means giving us a certain right to the other party. And how we can define license? Through a licensing agreement. When do I protect a trademark? How many years of protection do I get? I get 10 years of protection. When the 10 years is coming to an end, I can further renew it for a further period of 10 years. And it can go on and so forth in the similar way. Where are the trademark offices? Unlike copyright has only one office in India, that is in New Delhi. Trademark has various offices, and the jurisdiction, which is very important in any matter, jurisdiction defines in those particular states. For example, Mumbai has the state of Maharashtra, Madhya Pradesh, Chhattisgarh, and Goa jurisdiction. Ahmedabad has the state of Gujarat, Rajasthan, Union Territories of Daman, Diu, Dadar, and Nagar Valley. Kolkata, the entire Northeast comes under the category of Kolkata. Along with Northeast, there is Jharkhand, Union Territories, Andaman and Nicobar Island, all of them. New Delhi, Jammu and Kashmir, Haryana, Uttar Pradesh, Uttarakhand, Himachal Pradesh, Chhattisgarh, Chandigarh, all of them come under New Delhi. Chennai, all the South Indian states come under the Chennai category, and Union Territory of Pondicherry and Lakshadweep. As I told you earlier, the classification of goods is very important when we have to file a trademark application. A person coming to you to file a trademark, we have to figure out under which category of classes he falls in. Those category of classes are divided in 45 classes as per the NICE, and we are following the concept of NICE agreement. So 1 to 34 talks about goods. If you have to, for example, some bread manufacturer has come to you and asking for a category, you have to go and check under which class bread comes. It comes under class 30. So we have to file under that particular application. While we do trademark filing, we have to categorize the goods, services of the particular business, figure out which class it will fall into, and then file. Trademark protection isn't received for all the 45 classes. You will get protection only on that particular class and that you file. What are the grounds of refusal of trademark registration? Number one is devoid of distinctiveness. What do you mean by distinctiveness? Distinctive means lack of any character of that trademark. So if we cannot specify that particular characteristic of that trademark, the trademark department do not let you get the mark. For example, there was a very important case called classic versus classic. A person was saying classic, the word classic is a distinctive. Now, that guy wanted the classic mark registered for a certain business, which does not define that classic means too good. So here, the trademark granted him, stating that your business is letting you accept, and it is not stating about the characteristic of the product, and hence you get the registration. So we have to prove that the mark is distinctive when any sort of objection comes on the ground of devoid of distinctive. Refusal grounds is again of kind, quality. If my product talks about, my brand talks about quality, kind, quantity, intended purpose, geographical origin, all of that will be a reason for refusal. You cannot give out any such information while filing your brand registration. You have to be very particular and very clear, stating that this thing does not come into that picture. For example, Reliance, again I'll talk about, Reliance does not talk about any kind, any quality, any quantity, any intended purpose. It just talks about a brand. There is no meaning of that. That is what we can apply for trademark registration. Also, a very important ground is if the mark is a generic word. What if we find in our dictionary such word and we just take it out and you use it, that we do not get a protection. We have to have certain newness to that word. Then only we get a protection. That is what I mean by customary and current language. Grounds, if it deceives people or causes confusion. If I say a trademark is causing confusion to some other word, to a layman, the concept of trademark, whether it will be granted or not, it goes to, the judge has to see whether it is deceiving any layman. If it is deceiving, if it is creating any confusion, then it is a ground for refusal. If it talks about particular sentiments or hurting any class, it talks about it can be a refusal. Example, there was a international case with Buddha Cafe and Buddha Pub, which was because Buddha has a religious sentiment to it. It was refused, and also the word was not distinctive. That's why it was refused. If our logo or the form, shape has any sort of obscene matter in that, it is a ground for refusal of registration. National emblems, the word president, all of them are a part of things which do not allow registration. It is a ground of prohibition of registration. What is the process of registration? There is a new application called TMA, which we have to fill up. And along with that, we have to specify under which category the trademark falls under, whether it's a word category, whether it's a color category, whether it's a device category. We have to specify in that. We have to submit along with the fees, and we have to submit that to the trademark department. As soon as we submit the application in trademark department and we pay the fees, we receive a trademark application number. The day we receive the trademark application number, we can start using TM with our brand. From the time TM to R, it takes almost around a year or so, at least minimum 8 months. The process is they will be checking whether the first process will be whether the entire documents that we have filed are clear or not. If there is any issue with any of the documents, then there will be an objection raised, which we have to clear within 30 days. If it falls under any category of refusal or grounds of refusal of the trademark registration, it can be, the objection will be raised, and we have to revert back to the objection with the entire detail of why we have to grant it. If the trademark registrar is satisfied, then he will accept it, and if it is accepted, it will be open in the journal for 3 months. Within the 3 months, any outsider can oppose the mark, stating for whatever reason he can oppose the mark, and there will be the other party has the right to revert back to the opposition. A hearing will happen, and upon the confirmation by the trademark register, his acceptance, then only we shall receive the certificate. So I conclude my seminar here on trademark. If there is any question, please feel free to check. Vishal, if there's any question, you can get back to me.
Thank you, ma'am, for the wonderful session. Yes, ma'am. We have a list of questions by the participants today. So should we begin with the question answer session, ma'am?
Yeah.
Ma'am, the first question is from Toshi. How registered trademarks get recognized over other?
Registered trademark recognized over other trademarks which is registered.
Yes, ma'am.
Okay, so when I get a registration certificate, I get an application number with that. My certificate is covered with a number. And if whenever that trademark which is registered, it is always in the application website when we file it. If anyone else wants to copy that or wants to see whether that the mark is there, it is available in the website. When we do, before we file a trademark, we have to go for a public search and check whether such mark is already available in the website. If it is there, we cannot file a trademark.
Okay, ma'am. The next question to you is from Amisha. What are the formalities and government fees for major trademark transaction?
Trademark filing, the government fees is 4,500 for an individual and 9,000 rupees for a company. It can be any company, whether it's a partnership firm or a private limited company, any company, it is 9,000 rupees. The government of India has given a discount to companies who come into the category of startup. So if they have a startup certificate, they get a 50% rebate, and the government fee again reduces to 4,500. For a well-known trademark, the government fee is a 1 lakh rupees.
Ma'am, the next question to you is from Preeti Mishra. What is certification mark?
Certification of mark, as I had already explained to you, I'll just show you. See, I have already given to you an example of Mysore nuggets by Coffee Board. What happens is when I certify a mark, I give a category of mark. A quality of the product is being categorized on that. When I buy gold, there will be a certain category of gold. Correct? 22 grams, this grams. So they are certified by a particular department, and that department has to get registered under the Trademark Act to give you the certification. I gave you a very simple example of coffee because everybody drinks coffee and has an idea. But when I buy a type of particular coffee, I have to understand that that coffee has come from that particular place that is called Mysore nuggets. Similarly, there are other categories also.
Okay. Thank you, ma'am. Next question to you is from Chinmoy Patra. He's asking, I want to know that in case of violation of trademark, what are the usual defenses which a defendant may take in his defense who is facing a breach of trademark violation proceedings?
Can you just repeat the question?
In case of violation of trademark, what are the usual defenses which a defendant may take in his defense who is facing a breach of trademark violation proceeding?
See, as I already have explained to you, these are the grounds of refusal, as well as these are the same grounds for defending. So if I have to defend, I have to tell that this mark is distinctive. If I have to say that if my ground of thing is infringement, and if someone says that you are infringing the mark, I have to prove that the mark is not being infringed. How can I prove? I can prove with the different how my logo or my name is different from that name, how my word does not come into the same business genre as your business genre, how you are not a well-known mark. These are basically the basic things which we fight for during any sort of infringement matter.
Okay, ma'am. Next question is from Arya Panda, ma'am. He's asking, once a registry has issued a trademark, what is the procedure for removal of trademark by the same registry?
We have to file a withdrawal. We have to file a EMM stating the reasons of the removal, why it is, if I have to remove someone else's trademark register, I have to file a TMM stating that this mark is contradictory, it is having any sort of grounds of discretion or refusal. So it was by mistake registered. So I request you with the government fee of, I think the government fee is 1,000 or 1,000 rupees. I'm not sure. I've not checked it. So something around that time, a TMM application is called. It's called. So that we have to file it.
Okay, thank you, ma'am. The next question is whether we can apply for both copyright and trademark at the same time.
So when I file a trademark act or trademark application, and if I have to file for the same mark, same artistic work, a copyright application, I have to take an NOC from the trademark department. That NOC, there is an application form in the trademark where we have to mention that this trademark was filed by me, and I am the only person who is going to take the trademark registry or copyright application. They will give me an NOC certificate, no objection certificate, that I have to submit along with the copyright application. So it cannot be same time, but it will be within a certain time after we receive the NOC.
Okay. Thank you, ma'am. Now the next question to you is, for what duration the registration of trademarks is valid?
10 years. And then we can further renew it for further 10 years and it can go on and go so forth.
Ma'am, the next question is, how trademark differs from trade name?
This is the trade name, trademark, all are same. I'll just tell you, see. When I file a trademark application, if it can be a word mark. When I say word mark, it is the trade name of the business. Reliance is a name of the company. That is a trade name, the brand of the company. It's the same thing. There is no difference on that.
Okay, thank you, ma'am. Ma'am, the next question is that, will brand name differ from trademark?
No, brand registration is trademark. Why are we protecting? Because I want to protect my brand. So because of my brand protection, I have to file trademark. There is no other way of protection.
Okay. Ma'am, whether well-known trademarks, whether well-known can be registered under Trademark Act or Paris Convention?
Trademark Act.
Trademarks Act. Thank you so much, ma'am. And the next question to you is that, when one of the objective of trademark is to identify the product and its origin, how can we differentiate it from geographical indication?
Sorry, I missed your question. Can you just repeat it?
Yes, ma'am. When one of the objective of trademark is to identify the product and its origin, how can we differentiate it from geographical indication?
See, when I talk about geographical indication, I'm talking about a particular product famous in that particular city or in that particular region. For example, I gave you an example of Assam's Muga silk, which is very famous. Now, when I talk about the word Muga, I connect it with Assam. Whereas when I'm talking about the origin of the product, I'm talking about the manufacturer of the product. It has nothing to do with the city. And in fact, if my trade name has any city involved to that, for example, hammam would be Bombay's hammam, it would have been rejected. It is a ground of refusal if you are giving it a city's name. So geographical indication talks about the famous bamboo. We all know bamboo is very popular in Northeast, Mizoram. So bamboo protection comes from that is a type of bamboo. Okay, there are various bamboos and different. One of the type of bamboo is very famous in Mizoram. So they applied for geographical indication of bamboo. It's a club of one product, a club of it. There is no specifically that A bamboo, P bamboo, or there is nothing related to the manufacturer of bamboo, some product. Okay, whereas bamboo, after using the finished product of bamboo, I can file a trademark on that, but I cannot file a bamboo as a trade name. I hope I'm clear on that.
Yes, ma'am. Thank you, ma'am. Ma'am, Arya Panda has another question to you. He wants to ask that, when the application for rectification of trademark was filed originally, some grounds were not raised in the application. Is it possible for anyone to raise new grounds with respect to the same now? What is the associated rule under trademark?
Rectification for withdrawal of the trademark he's talking about, or he's talking about general rectification?
Ma'am, he's actually talking about the rectification which was filed originally and some grounds which are not raised in the application. So is it possible to raise new grounds?
Yes, we can. Again, there is TMM talks about the rectification application, and we can definitely give, if there is any ground which we think that it's missing before the rectification has been completed, before the process has been completed, and we think we can file another application form stating that these are the additional grounds of rectification.
Okay, ma'am. Ma'am, question is that, is it right to say that once a well-known mark always be a well-known mark, or the status of well-known mark can be taken back?
Once a well-known mark is always a well-known mark. However, if there is any issue on the well-known thing, they have to file a case. But there are no such cases which I can think of right now.
Okay, ma'am. Ma'am, how many types of goods and services are allowed to registration for trademarks?
There are 45 types of classifications specified given. Now, a person can file in all the 45 classes, but each classes would be a separate application. When I'm doing the application, when I'm doing the filing, I have to be very clear and that my business is also there. I cannot just take the registration and keep, because if there is any sort of objection on the mark, then I have to show that the mark is being continuously used.
Right, ma'am. Thank you, ma'am. Ma'am, the next question, if two person commence the business under one trademark and later they decide to separate, who is having priority over trademark?
If they are doing the business together, then they have to come up into, there are lots of cases like that which happen. So either they have to get out of their mark, they have to withdraw the mark, and there will be no priority given to anyone, or one of them can sell the goodwill to the other company.
Thank you, ma'am. Ma'am, the next question is there any source book to find what are all, where and what are all the trademarks registered?
In the Trademark Act, you will find the category, there are few categories of well-known mark, which all the marks are there. In the journal books, you will find all the trademarks which is registered or is getting planned to registered. All you can find in trademark website. Also, if you're thinking of certain marks, certain application that you can think of whether this mark is registered or not, you can go to a public search forum in the Trademark Act, and you can check the availability and whether the mark is registered or not. If it is registered, for how many years it is registered, entire details on the trademark. And for that, you don't have to be a lawyer. You can just do it on your own, even now.
Thank you, ma'am. Well, the next question is, what happens to a trademark if the person to whom it belongs dies?
What happens to a trademark?
If the person to whom it belongs dies.
It transfers to his legal heir. That I spoke about transmission, no? This one. Transmission under Trademark Act.
Okay, thank you, ma'am. And the last question for the day to you is, ma'am, does government has trademark for Aadhaar?
Government has trademarked Aadhaar? I don't know.
For Aadhaar.
I have to do the trademark search. I have no idea whether Aadhaar is trademarked or not. I really doubt Aadhaar will be trademarked. Yeah.
Thank you so much, ma'am, for taking all the questions of the participants. They are satisfied with the answers, ma'am. Now I would pass on the mic to our academic coordinator, ma'am, Monica Karula, ma'am. Monica, ma'am.
Thank you, Vishal. It's been wonderful listening to ma'am, and I'm sure the participants have benefited from this session. They've got a clear concept of copyright, which was addressed yesterday, and the trademark concept, how it is enforced, and how people can use their trademark. Snigdha ma'am has very well given the participants a clear picture of how it is done and used. Thank you, ma'am, for your enlightening lecture. And we look forward to having you more with ICFI Law School, Dehradun. Sir, over to you.
Thank you very much, madam. Madam Snigdha Sharma, we are very much grateful to you that you have spared your valuable time and have enlightened all our participants on copyright and trademarks in the last 2 days. It has been very informative and lucid presentation, wherein all our students have been much benefited. And therefore, I look forward to you in future that you will come to our university here and face to face, you will be enlightening our students. So I'm grateful to you from the core of heart, and I thank you very much. Okay, madam. Namaskar.
Namaste.
Thank you so much, ma'am.
everyone.
Thank
For
you.
giving me this opportunity. I really enjoyed having this lecture today and yesterday. It was very nice. Thank you, Vishal, for getting in touch with me.
Thank you so much, ma'am.
Thank you, Dean sir, and thank you, Monica ma'am. Okay, I'll leave then.
Okay, madam. Thank you very much.
Thank
We'll meet
you.
again.
Akhilesh sir. Akhilesh sir. Akhilesh sir.
Yes, sir.
Sir, do not close the meeting now. Just after 2 minutes, close it.
Yes, sir.
Just after. Sir, do not close the meeting now. Just after 2 minutes, close it.